Joining us now is Jeremy Saland, a former Manhattan prosecutor. Jeremy, thanks so much for being here this morning. Good to see you.
You as well.
Okay, so let's start in California, and then we can kind of zoom out. At its heart, this trial that's going to start in California is about how much power the President of the United States lawfully has over the military on domestic soil. What's at stake here?
It's a really interesting question, and the circuit court that appealed the initial decision that said basically we give wide deference to the president to enact this law and to use his powers, but really at the soul of this is there's a state right issue. Can the federal government, meaning the president, say, you know what, I'm going to just put in the military as a civilian police force on American soil when there's a statute that specifically says unless Congress says you cannot or you can do so, then you cannot. At what point and what is that threshold that the president can use this? And then we're hearing Washington, D.C., what is next?
Right. And look, there's also this question over kind of getting at what you're saying, the 10th Amendment argument, which Governor Newsom's attorneys are arguing that by overriding California officials in this case, who did not want the National Guard to come in,
correct.
Didn't ask, said, in fact, please don't, that the president violated the 10th Amendment that governs the power sharing between the federal government and the states. How strong is that argument, do you think?
Well, the argument is, unless it's explicitly carved out for the federal government, it goes back to the states. You know, it's not just something that the federal government can come in and just do without following the law. It's a strong argument. And again, I would say that we heard from Judge Breyer, who happens to be the brother of the former Supreme Court judge, who said, you know, the president is not the king. The president can't just willy-nilly say, I'm going to enact a law and say this is what's going to happen. There needs to be a rebellion. There needs to be, in this particular case, an insurrection. There needs to be something that requires the federal government to say, we are needed to enforce the law and prevent the obstruction of the law, to protect federal property, personnel, and the public, because there's a failure and inability of the states to do so. And that's really not so easy. But I would just share with you that even if Judge Breyer says, I agree with you, state, which it seems like he has based on what he's previously said, we're going to find this litigated even further. It's not going to end there because Donald Trump is constantly using the courts to challenge the courts, right or wrong.
Yeah, certainly. And look, more broadly, to that point, the Trump administration continues to take aim at the courts. They are suing, and there are lawsuits against judges that are critical of the White House. This is supposed to be a check and balance with using the judiciary and the executive. Is the judiciary losing its ability here? You know,
I hesitate to use this word, but I think it's necessary. To a certain extent, Trump is neutering the judiciary, and it's incredibly, incredibly frightening because they only have so much power. Certainly, someone could be held in contempt as an individual, but if you as a judge is going to refer something for prosecution, and you have a Department of Justice that is doing the president's bidding and disagrees with you, how far can you go as a court? It's concerning, and it should concern everyone extremely about what's happening with the courts.
That is what is at stake today, and will continue to be. Jeremy, thank you so much for being here. We really appreciate it.